Welcome to the Trust Factor Radio, bringing you interviews and insights to unlock the power of the subconscious mind to create authority, credibility, and trust. With your host, the Authority Architect, and best-selling author, Neil Howe.
Hello and welcome to the show. This is your host, Neil Howe, and today my special guest is President and CEO of Advocate Capital, Michael J. Swanson. He and his team help plaintiff lawyers get even better results for their clients. Michael Swanson has been a shareholder, member of the board of directors, chief executive officer, and member of the credit committee of Advocate Capital since 2000. His daily role at Advocate covers a wide range of activities, including client relations, strategic planning, credit underwriting, marketing, and public relations. Mr. Swanson is the author of How David Beats Goliath, Access to Capital for Contingent Fee Law Firms. The book is a definitive common sense read that explains how contingent fee law firm funding works, who provides it, what it costs, and how law firms can acquire and use it effectively. In addition to his responsibilities at Advocate Capital Inc., Mr. Swanson has been a lecturer at seminars and CLE programs nationwide, focusing on financial management and operational excellence at trial law firms. Well, this is definitely a niche that needs some help, and we're looking forward to finding out more from Michael Swanson. Welcome to the show, Michael.
Well, thank you very much, Neil. It's good to speak with you.
Well, after that little intro, I'd like to hear just a little bit more about yourself and Advocate Capital and how you became involved in this business.
Well, sure. We are primarily a team of business people here at Advocate, about 45 employees. None of us are lawyers, but we're all passionate about helping our plaintiff lawyer clients get even better results for their clients, mainly through our AdvoTrac case expense funding service. Have to admit that when my business partner, Dan Tossick, and I bought Advocate in 2000, when it had one customer, we really didn't know what plaintiff lawyers did, but we learned very quickly that they help people all day long. And so we are very happy to be on a winning team. But more importantly to us is that we're on a team that helps people who help people. So we're funding and tracking about 75,000 cases nationwide at the moment, and that's growing about 15% a year. And those are not cases. Those 75,000 so-called cases are actually people who are being helped by our clients, people who have recently maybe gone through the worst day in their life, maybe lost a loved one due to negligence or some horrible injury or had their life changed forever. So if you count them family members, we think it's hundreds of thousands of people across the country now being served by our clients, and we get to vicariously participate in the great work that they do in their communities.
Well, excellent. I really love the fact that you are that educator and advocate, and you're helping people that help other people. I love the name that you have for your company, Advocate Capital. Tell me about the plaintiff lawyers then. Is that just your sole niche that you work with, is the plaintiff lawyers? What exactly is a plaintiff lawyer then?
Sure. We do work exclusively with plaintiff lawyers, or at least lawyers who do some contingent fee work, and those are typically folks helping individual plaintiffs. Interesting, one of the things I do with new employees here on their first day is I sit down and meet with them, and I ask them, do you know what the Seventh Amendment of the United States Constitution is? And of the probably 100 people we've hired over the years, only one person knew that. So I'll ask you, do you know what the Seventh Amendment is, Neil?
I have no clue.
Right. Well, the framers of our Constitution came back after it was initially ratified and added 10 additional amendments to the Constitution. Most people are familiar with the First Amendment, the right to free speech, the Fourth Amendment, the right to be free from unlawful search and seizure. But very few people know about the Seventh Amendment. The Seventh Amendment gives you and I, as citizens in the United States, the right to a jury trial in economic disputes in excess of $20. And most folks don't realize that's even there, but the framers really understood, after going through the revolution, how much protection they needed to provide for individuals who would be up against large, powerful institutions like the government and large corporate entities. So they created this right under the Seventh Amendment for you and I to go before a panel of our community members, we call that a jury, and to have the dispute heard, and then to have that jury, our fellow community members, make a determination as to what they are going to permit to happen in the community. What kind of corporate activities will they permit? And they have the ability then to render a verdict and to make an economic judgment. And that judgment can include things like judgment for lost wages, medical expenses, and they also, in most jurisdictions, have the right to award additional monetary compensation for pain and suffering, psychological damage, and then importantly, punitive damages. And punitive damages are very important. Of course, the actual losses that a plaintiff experiences in, let's say, a car wreck, if they've been hit by a drunk driver, they're going to have medical bills and expenses in repairing their car and things like that. Mm. And so lawsuits in this country help make plaintiffs whole economically. But another very important aspect of a civil lawsuit is the ability for the community to penalize corporate entities that are conducting malfeasance or are negligent in their behavior. And it's through this kind of enforcement of community standards that the juries around the country are able to make it cost a lot of money for a corporation to do wrong things or to fail to do the right thing in many cases. A great example is in the recent years, you've probably heard of the many cars made by GM that were recalled, about 30 or 40 million cars due to a defective ignition switch. Have you heard about that maybe in the news?
I have, yes.
Sure, most people have. Well, that was brought about by a very tragic case. A little history on that. For 10 years, GM was settling cases out of court without getting to a jury and signing confidential settlements with the plaintiffs. And they kept it confidential because they didn't want the word to get out, and they didn't want to have to do that recall because they did the economic calculation that it was cheaper to settle cases over the years out of court than it would have been for them to recall these vehicles. Well, for 10 years this happened. There were deaths linked to that. Many people died because of it. And then a very brave lawyer in Atlanta, your hometown, took on a case involving one of these ignition switch problems. And his name is Lance Cooper, and Lance is a customer of ours. And Lance was able to get our assistance with funding this particular case. He had just himself and a paralegal, and he had to hire experts and engineers to go across in the Southeast United States and collect ignition switches from GM vehicles from junkyards and lay them out all out over time. And what he found was that at a certain point in time, GM changed the ignition switch design, but they didn't change the part number, and they didn't tell anybody because they wanted to keep it quiet because they realized this is a defective ignition switch, but we're going to keep it quiet. We're going to change the design for new vehicles, but what about all the vehicles already on the road? Well, they wanted to keep it quiet. And so he discovered this throughout his case. His case involved a young woman who had already taken her car to the dealer to be repaired once because she had been driving and her car shut off. That was the problem with those switches. They would just shut off. So she took it to the dealer. They looked at it and said there's nothing wrong. So about a week later, she was driving to her own birthday party to meet her parents. The ignition switch turned off. Now, when you're driving a vehicle and the ignition shuts off, you lose your power brakes, your power steering, your airbags, and your seatbelt tensioners. So you can imagine how horrible it would be to be going down the road and suddenly you can't control your car. Well, that's what happened to her. She crossed the center line, crashed into another car who had other occupants who were injured, and she was killed. So this is the kind of thing that had been happening for many years across the country. What Mr. Cooper discovered was that the engineers from GM actually lied. Afterwards, he discovered in the deposition. So now they had signed a confidential settlement in this case. So what he did was go to NHTSA, the National Highway Transportation Safety Authority, and urge them, please look into this matter. There are tens of millions of unsafe vehicles on the road, and people are getting injured and killed by them all the time. And it was his work that got NHTSA to do that recall that we all heard about. So, long story short, this is a great example of how lawsuits make us all safer, because those 30 or 40 million vehicles have been repaired now and are not driving around with those faulty ignition switches. Most folks don't realize that. They don't know that they were made safer thanks to what Mr. Cooper did and thanks to the recall. And I think that's the kind of thing we really love helping with. And we're all safer today, you and I, driving home from the office because of that recall.
Well, when you mention cases like that, those are the things that movies are made of. And we do hear about some of these things in the press, but there's a lot of cases that go unseen because people don't understand their rights. So what kind of problems do your clients have when it comes to that? Is it much of an education part to the business?
Absolutely. So we provide education in a couple of areas. One of them is to help educate the public through our employees and the other production work we do about the truth about what plaintiff lawyers really do. So a plaintiff lawyer is the keys to the courtroom for you and I. You know, if you got hit by a drunk driver on the way home today and needed to hire a lawyer, most people can't afford to hire a lawyer and pay them $500 a year, an hour for 2 years to prosecute their case. They just don't have the money for that. So along comes the plaintiff lawyer who is willing to take a case on a contingent basis. So the contingent fee contract is crucial to bring life to our Seventh Amendment rights. And under a contingent fee contract, the law firm agrees to prosecute the case for as long as it takes. They agree to advance all the expenses necessary to prosecute the case. And they agree to only get paid if and when there's an actual settlement or verdict paid. And then they normally get their expenses back, and then they split the award, typically 1/3 to the law firm's legal fees and 2/3 to the plaintiff. So as important as the Seventh Amendment is, if there were not lawyers willing to take a case on a contingent fee basis, the Seventh Amendment really wouldn't mean much to most of us because, yeah, the right's there, but how do you get to the courtroom? You need a lawyer, and most people can't afford to hire them. So thankfully, these lawyers are very brave. They're very entrepreneurial, if you will. They take on great risk because in a law firm, of course, you have employees and payroll, insurance and taxes and utilities and rent. Those all have to be paid. And yet you're signing up cases on which you're not receiving hourly fees. You're having to wait and get paid maybe 18 months, 24 months, 3 years later. So it's very, very challenging business model, if you will. They face many challenges. From a capitalization standpoint, first of all, generally speaking, a law firm cannot sell stock in its business. So if my business partner and I wanted to grow Advocate even faster and we wanted to raise growth capital, we could go out and sell stock and bring other investors into the business. This would allow us to take that capital and then, ramp the business up further. And those investors would share with us in the profits and losses on a pro rata basis. Well, only a lawyer can own a law firm. So law firms are not able to go out and sell equity or receive growth capital from outside investors. So that's one way that they're constrained from a capitalization standpoint. Secondly, most banks really don't understand the contingent fee contract to be a true accounts receivable. So in a service business, let's say you're a plumber, you do some work, you send an invoice to your customer, and they pay you. Well, that plumber, if they had a lot of invoices, could take those to a bank and say, these are my accounts receivable. I've done the work. I've billed my clients for them, and I expect to collect these dollars over the next 30 to 60 days. A bank would recognize that as a true GAAP-rated receivable and might be willing to allow that plumber to have a business line of credit based upon their receivables. Well, if you think about a contingent fee lawyer, when they go to the bank and say, I'd like a loan based upon my receivables, the banker says, okay, let's see your receivables. And they're expecting to see invoices. Well, what they show them is, well, I have these contracts, And these contracts with my clients will enable me to get paid eventually when we win the case. Of course, if we lose the case, we don't get paid at all. Well, the banker says, wow, we don't know how to put a value on that. In a worst case scenario, if something goes wrong, they don't know how to liquidate that. And they will typically say, let's just put a lien on your house. So access to bank capital for contingent fee law firms is constrained in this business, in this country, because banks don't recognize the contingent fee contract to be a valid receivable. So these are some of the challenges that plaintiff lawyers face. They also face a big uphill battle when it comes to public relations, right? So you've seen some cheesy commercials on TV, probably late at night. There are some lawyers that make really bad commercials, and unfortunately, that casts a bad shadow over all plaintiff lawyers. But there are about 90,000 plaintiff lawyers in the country, and a very small percentage ever make it to TV. So there's a reputational issue that they face just in life and in hiring people to come work with them. There's this idea that they're all ambulance chasers. So what we've done at Advocate is first understand in a very deep way what they do. We appreciate what they do. And then we've designed a very specialized kind of niche product to help them with a particular aspect of capitalization. So we're not a one-size-fits-all. We are targeting the case expenses that a law firm has to spend to prosecute a case. So if they're going to prosecute a case to the trial level, there are going to be expenses along the way. So they'll have to ask for medical records. That costs money. They may have to hire expert witnesses. They may have to write a check for $10,000 just to get an expert to review the file. There will be deposition expenses, travel expenses, trial exhibits. And generally speaking, a rule of thumb is that if a case is going to be worth a total of $100,000, it's going to cost a law firm about $10,000 to prosecute that case. So I mentioned before, there are all the issues with overhead and not getting paid. It's even worse than that because they have to come out of pocket for the hard case expenses required to prosecute a case. Now, the law doesn't say they have to pay for those expenses. It's just been kind of the standard operating procedure because who else is going to pay for them, right? The plaintiff can't afford typically to front those. And so the tradition has been that the law firm advances those. So not only are they out their overhead and these kinds of expenses, they're having to come out of pocket for tens of thousands of dollars in many of these cases. A typical client of ours has about 200 cases in various stages of development. Some they're signing up just this week, some are resolving this week, and all stages in between. The net effect is that they build up this large dollar amount invested, if you will, in their ongoing case expenses because as one case settles, they have to use those funds to pay for case expenses for a new case. And over time, that money can really add up. In fact, it can easily be hundreds of thousands of dollars. It is for most of our clients. And for many clients, it's millions of dollars. Millions of dollars that they've had to pay into their cases that they don't get paid interest on that money. The only cash available for use for anything at a law firm is after-tax cash. So this is after-tax cash that the owners have essentially loaned to their business interest-free with no coupon and really no hope of repayment until someday, maybe when they wind their practice down. So we've really focused on those case expense dollars. And interestingly, so they have to pay all this money. The IRS says that case expenses advanced by a plaintiff lawyer are not expenses. Right? Because they come back to the law firm about 95% of the time, the IRS has ruled that the monies they've put into their practice for case expenses are really a loan they've made or a lot of miniature loans they've made to their clients. So they can't even report these expenses on their income statement to reduce their taxable income. They have to book them as an asset on their balance sheet as a loan. So it's kind of a double-edged sword. So we've really focused on that aspect of it, and we've taken advantage of the fact that around the country, whenever the bar has opined on case expenses and how they should be treated, they've consistently said that if a law firm decides to borrow money to fund those case expenses from a third party, such as Advocate, and if the technology is in place such that the law firm can document, this is exactly what I borrowed for this client, and here's exactly the interest I paid to the lender for this client, specific to the penny. They're able to essentially get reimbursed from the case for the borrowing costs, just like all the other case expenses. So at the end of a case, when they sit down with their client, they will typically say, okay, our fee is a third, and then we also had these expenses, and they show them the receipts. We paid this expert witness this much and such and such. Well, our clients now have an additional receipt at the settlement, which is showing all of the case expenses they borrowed from Advocate for that particular case, and it shows the interest they paid us during the case. So they're able to get back all of the borrowing costs they paid to us during that particular case because we're able to keep track and document it. So we have about 480 law firm clients. As I mentioned, we're funding about 75,000 cases, and we're funding and tracking those real-time 24/7 so that our technology is standing by and ready to print out a receipt whenever they're ready to close a case. So the value proposition really to try to help these plaintiff lawyers is that they're able to get back the cash that they've tied up in their cases back out of the practice, or they can leave it in the practice too, but they're able to get it out of the cases by borrowing it from us. And the net cost of borrowing on these case expenses is zero for the cases that they win or are successful, and that's about 95% of the time. So our clients get back on average about 95% of what they pay us. So the net cost of borrowing for our clients on average is well below 1% per year. So the concept is, because we're really only dealing with successful law firms, our clients don't need the money, but we help them understand that, look, if you can get back the cash you have in your cases at a net cost of less than 1% per year, could you find something good to do with that, right? Mm. And of course they can. Every law firm's different. They have different goals. We try to come alongside them at first really and just hear about their goals and then help them understand how being our client could help them achieve those goals. They may be wanting to grow. Well, becoming our client, we give them the capital, very low cost capital, to be able to hire more employees or to do more advertising or to lease additional office space. They'd be able to help even more people in their community. And there are other challenges that they face, right? So there are law firms that can't afford to prosecute their cases. Now, no one, they wouldn't want to admit that, right? But if you walk into a law firm and you have you need help on a case, it's very hard to know, does this law firm have the financial resources to pursue my case? And many of them don't. So there's some conversations that happen around the country at contingent fee law firms every day. One of them is, hey, we just signed up a giant case. It's going to be very expensive. Let's try to settle some of these other cases a little earlier so we'll have the money to prosecute this big case. Now, that shouldn't happen. That's malpractice, right? Because the smaller cases deserve full prosecution efforts as well, but that's a reality. Another reality is, hey, payroll is Monday. Let's settle a few cases because we need to make payroll. And again, that's malpractice. So the ability to push forward aggressively on their cases that our clients have makes a huge difference. First of all, they're going to get better results, and they're going to get better results because they're going to invest in the best experts and the best trial support, and that has a direct impact on the results they're going to get for their clients. And they're also going to shorten their time on desk. The time it takes from signing a client up to concluding the case tends to shorten because they don't have to delay. They don't have to wait a week or two to hire that expert on this case because they have other cases. So their ability to push forward aggressively, hiring the very best trial support that they can, shortens the time on desk. So they can turn many more cases in a year than they used to be. And that has the effect of helping more people and getting them better results for their cases and increasing the law firm revenue over time, because if they're getting better results, they're getting more fees. And if they're turning more cases every year, obviously that translates into more fees as well.
Mm. Well, it certainly sounds like a good plan to go with. Is this standard across the industry, or do you still have to get this word out and education to plaintiff lawyers out there?
Yeah, it's funny. We're kind of like the I guess we're the 19-year overnight success story. We've been doing this since 1999. I've been involved since 2000, and yet there are many, many plaintiff lawyers who don't realize this service is available to them. And it's taken us a long time really to perfect the ability to gain the right clients. So if you're a commercial lender or a lender of any kind, people who really are in difficult spots will find you, right? They're Googling at night to make cash or make payroll. And those folks have always been able to find us. We only fund 1 out of every 4 applications we take because where we are is at the high quality, low risk end of the lending spectrum. So our typical clients have been self-funding. They truly don't need the money. It's not that they're in trouble, and it's hard to get their attention, right? So they're not going to be perusing the internet looking for funding for their cases because it's always worked well for them this way. You know, they don't really realize how much better they could be doing. So what we do is come alongside them. We attempt to make contact with them and build a relationship and build trust over usually several years before they become a client. And that's where we do a lot of other education to help with that. So in our Nashville studio, we do quite a few different types of videos. One type of video highlights some of the important casework that's being done by our clients and other lawyers around the country. I wrote a book, as you mentioned in the introduction, called How David Beats Goliath. And that the name of that book was suggested to me by my business partner and friend, Dan Tossig, because it really is kind of a David versus Goliath thing. Even if you're a very successful law firm, you're going up against State Farm and or Nationwide and this kind of thing. So it's a David versus Goliath thing. So in that book, I put it together to help plaintiff lawyers generally because we think a rising tide lifts all boats. We're trying to educate future customers to run their law firm financially well enough to become a customer eventually. It's the only book ever written to help plaintiff lawyers understand finance. And much of the book is actually, a lot of it's the inverse of what we've seen done wrong out there. We try to help folks avoid those pitfalls. So we do video content based upon the book. I speak around the country based upon the book content to help plaintiff lawyers. We also do webinars to help them on various business topics like HR issues or maybe IT or insurance. So we're trying to give them all the tools that we can. I think that when a prospective client starts to look at us, I think they see that we're engaged, we're involved, we're really trying to help all plaintiff lawyers, and I think that goes a long way to landing clients for us. But it took a long time to figure out how to do that. How do you sell funding to a law firm that doesn't need it?
Right, that seems to be a big problem. Speaking of that, what kind of fears or apprehension do some of these plaintiff lawyers have when they come across your message?
Well, I think there are several fears. One is the fear of doing something new, right? That's always scary, especially if things are going pretty well. You get kind of comfortable and you don't necessarily want to change. I think it's fear of the unknown. What will their clients say now that they're going to pass interest through? Well, we know they're not going to complain because we wouldn't be where we were if all the plaintiffs were complaining about it. So there's some fear of that. Sometimes they're fearful it will make them less competitive in their marketplace. It doesn't. It actually makes them better lawyers, get better results, and they get more clients and better reputation. So I think those are the main fears. And of course, a lot of folks are debt averse, and that's a good thing. Debt is a huge problem right now. It has been for a long time. The student debt in this country, for example, eclipsed credit card debt several years ago. So everybody reads about that. Debt can be a bad thing. However, debt used in a strategic, controlled way for a business, if they can use that leverage to help them grow and get better results, it can be a very effective way, especially because, as I mentioned before, raising equity is not an option for them. So they're going to have to use some kind of, if they're going to go outside, use some kind of outside financing of some sort. Then they also hear about some of the stories out there of lawyers who get in trouble and borrow too much money. And those are the folks that we turn down, and they go to other very high price lenders and they dig a hole. So I think, they've heard those stories and seen a few movies actually based upon that.
Right. Well, let's talk about some of the success stories, Michael. Who It springs to mind a company that was coming to you for a little bit of help. How were you able to help them, and what was the outcome for that company?
Sure. Well, I mentioned Lance Cooper as a specific case, but our clients on average grow with us when they come aboard for the reasons I mentioned previously. Thinking about a particular client, I have one in mind who I'm not going to mention the name of this particular client. It was two lawyers that came to us. They had no employees, younger fellows in a major metropolitan area, and they wanted to start with us. Well, they weren't our typical client at that point because they didn't have much of a track record. They had a little bit of net worth built up. They'd saved some money up, which was a good thing. And, I mentioned before, we have no lawyers on staff, so we couldn't evaluate their cases. That's how we operate. But over the years, we've become experts at picking the right law firms and lawyers to work with. We've been reading the financial statements, business plans, tax returns of plaintiff lawyers every day for the past 18 years. And so when you do something like that all day long, you kind of know how to spot the right ones, right? So we recognized that these two lawyers had a lot going for them, both from a legal standpoint, but also from a business standpoint. They had a real business understanding. We liked their business model, their business plan. We could tell that they weren't just your typical plaintiff lawyer. Your typical plaintiff lawyer has an undergrad in history or psychology or sociology or English. Nothing wrong with those degrees, but they don't teach you how to run a business. Then they go to law school, you don't learn business there. So they're kind of thrown into it. But these two, we thought, they're going places. So we set up a line of credit for them, I think around $75,000, which is our minimum, right around there. And this is probably 10, 12 years ago. Well, they got on board and they just ran with it, and they've done such a wonderful job. They're dominating their market now. They have significantly added to the number of people they're helping in their community. They've diversified the law firm into other types of cases, and they have grown their revenue and net worth such that we've been able to recently renew them at their renewal time, and we've finally now increased their line of credit. It's at $6 million. So they went from $75,000 of case expense needs to $6 million, and their profits and their net worth have grown in a similar way, and so has the couple thousand people that they're helping in their community now are getting the kind of legal representation they deserve. And that's just one example, and there are many, many others, because that is typical, although that it's not usually from 75,000 to 6 million. That's a pretty meteoric rise.
Well, it's a great story, and it's great that you're able to put people in a position to help more people. That's what they do. So if there's plaintiff lawyers out there that are listening to this and they're looking for some capital to handle some of the expenses in their business, what kind of questions should they be asking the financing firm?
Right. Well, it's kind of interesting. We've talked a lot about finance, and of course, we are a finance company. We make loans to law firms, lines of credit. But really, anybody can make a loan, right? Mm-hmm. I mean, banks make loans all the time. Your uncle can loan you money. What's really the key in this aspect of it, though, is that pass-through of the borrowing costs of the cases. And most people don't realize it, but we are more of a tech company than a commercial lender. I mean, we do make loans, obviously, very successfully. But what makes Advocate Capital special is AdvoTrac. So AdvoTrac is our proprietary software that we built from the ground up starting 19 years ago that we've continuously improved. And AdvoTrac, we run our business on AdvoTrac, and we track all those 75,000 cases. We're processing about 2.7 million transactions per year in AdvoTrac. So we're running the business on that. But what's really key is that value proposition I mentioned earlier, which is AdvoTrac gives us the ability then, and our clients can go online and access their accounts to print out that all-important documentation to show their clients, here's every step along the way in your case of what I borrowed and the interest I paid my lender, and it's that receipt out of AdvoTrac that gives them the ability to get back what they've paid us. And that's the basis of it. But we've then wrapped a lot of different services around that technology for our clients. So because they sometimes need help with business aspects, we've built a team of training folks here at Advocate who will go into a law firm usually electronically, remotely, and help them get started with our program so they don't have to figure out, how am I going to do this? We do that for them. In fact, we have, I think, 5 people now, 5 team members on staff who are certified by Intuit as QuickBooks Pro advisors. So we really go a long way to provide training to them. We provide free QuickBooks training, for example, to all of our customers on any topic. We can get them discounts. We have enormous amounts of reporting available to clients right through our 24/7 secure web portal. We're 100% electronic, so we have built into AdvoTrac the ability for our clients to go online, request funding for a case electronically with a click of a mouse, pay off a case with a click of a mouse. All this is done very rapidly and electronically, so they're not having to deal with writing checks or receiving checks from us. So we've really wrapped a lot of the human training support aspect around the technology to deliver that wow experience for our clients. So if someone's thinking about talking to a lender about case expense funding, it's important to ask more than what's the interest rate. What's the support that my staff's going to receive from this lender? What's the technology look like? Take it for a test drive. And then we actually, if folks are in the market for that, we've created a couple of important tools for that. One is a list of questions to ask a case expense lender. So we have developed a PDF 3 or 4 pages long to help people do their due diligence on a potential case expense lender. If they want to contact me, I'm happy to have a copy of that sent to them. So if they want to compare and contrast, it'll show them, here are the things you need to ask about. We've also developed a due diligence checklist for them that they can use to record the answers back from case expense lenders and really do a side-by-side, apples-to-apples comparison. And again, we're happy to send them a copy of that. We think the educated consumer is the best consumer. And if they take a good hard look at what's available in the marketplace, we know that they'll see that our team and AdvoTrac is a superior solution.
Definitely. Well, it's nice to have the tech on your side. It makes a lot of things easier, but it's better to have that advocate in your corner as well. So tell me, what is the best way, Michael, for people to reach out to you if they want to talk to you and get some help?
Sure. Well, they can tweet to me at Michael J. Swanson. I'm on Facebook. I think we sent you a link to that on this page. Of course, you can just go to advocatecapital.com to learn more about us and to reach out to us there. Click on the About link at the top, and you'll see our team there. Of course, there's a page I have, and they can visit that page and just shoot us a note or live chat us up on the website. So advocatecapital.com or tweet to me at Michael J. Swanson. Excellent.
And I'll include all that information in the show notes so that they can just click on it there. Well, Michael J. Swanson is President and CEO of Advocate Capital. Thank you very much for being my guest on the Trust Factor Radio today.
It's been a pleasure. Have a great day.
And to our listening audience, if you like what you hear, hit that like button and share, and we'll see you next time on the show.
You've been listening to the Trust Factor Radio with Neil Howe. To learn about the resources mentioned in the show and to listen to past episodes, go to thetrustfactorradio.com. To get a copy of the book, The Trust Factor, go to thetrustfactorbook.com. If you are ready to act now and build your authority, credibility, and trust, schedule a consultation with Neil at theauthorityarchitect.com.